sealed certain documents about the Public Protector and President Cyril Ramaphosa. Remember, he said some of the bank statements were actually confidential. So that was one case. Also, the Public Protector suffering another blow in court. It's the personal cost order going against her, saying that she must pay about 7.5% of the legal costs. And this has to do with Estina report. What does this all mean for her? Let's get some analysis now. And we join on the line by political commentator Khaya Sithole. Khaya, always a pleasure having you on the program. What's your reaction to this defeat in court with regards to the Public Protector?
Good morning and good morning to the listeners. I think the judgment today was to be expected because if you do recall, what had happened is that this matter has been pending, and when it was first brought to the fore, the response from the judge was that since a similar issue is already in front of the Constitutional Court, it will be premature of this court to make a judgment until we know what the direction is from the Constitutional Court. We then saw that the Constitutional Court did indeed confirm an earlier order that said, yes, in some instances, it is indeed warranted to award personal costs against the Public Protector if in her conduct relating to any particular investigation is found to be wanting. Now, in relation to the Estina dairy farm, the similar issues that had emanated in the Reserve Bank report were also ventilated in relation to the Estina dairy farm. So, of course, it was very unlikely that this particular judgment was going to depart from the precedent that has been confirmed by the Constitutional Court, and it was really just a matter of the quantum and the size of the personal costs that are then attached to the Public Protector in her individual capacity.
Khaya, in the court of public opinion, what does this mean for the Public Protector?
It is not a very good thing. I mean, it is very bad optics, and the key issue here is that it does give the impression to the general public that perhaps the way in which the affairs relating to the investigation at the Public Protector's office are being conducted is at odds with the law. Because if you're going to get so many court orders, if you're going to get so many judgments saying that, look, this is clearly not the way things ought to be done, it does make a lot of people start to wonder about the quality of the investigations that we're seeing there. But of course, I think the bigger issue here is that the precedent that has been set in that a person who is litigating in a representative capacity, as she does, can now be attached with a personal cost order. It has broader implications for a lot of not just Chapter 9 institutions, but other civil servants who themselves, in the course of conducting their duties, find themselves having to defend matters in court. On the other hand, it does perhaps raise the level of awareness within the Public Protector's office that perhaps going forward, the way in which it conducts its affairs, the way in which it conducts its investigations needs to be a bit more thorough than it has been in the past.
Look, with regards to all these personal cost orders against her, there's been this initiatives from her supporters to raise some funds in order to help her in this regard. She did say that she was seeking legal advice in order to find out whether she can accept this or not. But what's your take on this? Can she?
I mean, it is a personal cost order, and the problem with personal cost order is that they don't ever take into account exactly her capacity to pay. So, of course, we are fortunate enough in that because she's the head of a Chapter 9 institution, we have an awareness of how much she does earn. But in any other instance, we might not know how much a person earns, and for a personal cost order to be attached against them, which might run into millions in particular instances, it does obviously then raise the question of how is this person expected to raise his funding? And I think in this particular instance, she's well within her rights to explore particular avenues of saying, this is where I'm going to source the fund. I don't think there can be anything illegal about it, because at this stage, once you said it's a personal cost order, you are saying that she must pay the money out of her own pocket. How she sources the money should not really be the concern of the legal structures.
Khaya, a reporter, Sipho Stearman, was reporting what the court heard today, and it said she failed the people of Vrede in her report. When we were speaking to her spokesperson, he was saying that the Public Protector doesn't agree. She's standing by her Vrede report. She's digging in her heels, holding steadfast. What do you make of that?
Look, it's a difficult one because remember what makes the Freedom report unique, and I suppose also the Reserve Bank report, is that these were inherited reports in that by the time she came into the office, there had already been some preliminary work, at least, that had been done in relation to these particular reports. Now, whether that probably then sort of influenced the way in which she approached it to say, look, some of the work has already been done, I'm going to rely on it, and then I'm just going to do a tie-up. That might be the problem here, in that if you do not start a process from inception and you rely on pre-existing information and it later transpires that the people that are implicated are saying, no, actually we still expected you to come and consult with us, we still expected you to do bigger, more digging, and you didn't do that, that does become the problem. And I think we cannot be unaware of the fact that her biggest problems have really related to our investigation that she herself inherited. Now, whether we should approach that process differently to say, if you come in and there are already reports pending, you still have the responsibility to treat them as your own reports, to take full ownership and deal with them as you would with a brand new report. That might be the learning that the Public Protector's Office is going to get out of all these processes.
The President, Cyril Ramaphosa, wanted certain documents that was used by the Public Protector not to be made public, certain records. He seemingly won that battle. Was that a foregone conclusion?
No, I don't think it was a foregone conclusion because, again, the way the process tends to work is that by the time you start challenging the findings and, the basis for the conclusions that the Public Protector has made, you are literally then saying we want a third eye to look into this. And that third eye is indeed the judicial system. And, of course, we know that that makes it all the matters and all the documents a matter of public record. What created the tension here is that the President was firstly disputing the way in which the Public Protector had been able to access the information which had then informed the way she formulated her conclusions. She has now come back and said, well, actually, this was the source. This was the credible and legitimate source that I used in order to actually get access to this particular document. So, of course, it was always a question of semantics. The judge is always going to have to make the call to say, well, now that she has proved that she did receive them legitimately, then the question becomes, is it in the public interest for this document not to be released or to be released? And I think that becomes the key talking point here to say, in most instances, the standard procedure would be it is indeed part of public record. But if the President can then convince the court in one way or another, I don't know how he's going to do it, that this is a unique situation that warrants an intervention from a judicial officer to say, in spite of what the law says, in spite of what the existing practice is, we're going to do things differently here, then that is going to be the next challenge that we're going to operate and see the outcome of.
Yeah. Khaya, one of the reports in terms of the remedial action was that she asked the National Director of Public Prosecutions to investigate prima facie evidence of, or prima facie material or evidence in that respect of money laundering with regards to the President and the Bosasa issue. Some are arguing, Khaya, that this might be crossing the line here, and she might be held liable in terms of criminally liable because she's asking another constitutional body to act in terms of independence. What's your take on that?
Yeah, I think that's a bit of a stretch. I think a person speaking to another constitutional body and saying, look, in the course of my investigation, I've stumbled upon particular information that might be of interest to you, that cannot quite possibly amount to criminal conduct. The law might be that, you cannot interfere with how the NPA, for example, conducts its affairs, but I think the concept of interference has to be something much broader than a person simply saying, hello, Shamila, I've stumbled upon this particular information, please could you look into it? So I think it is a stretch. One might actually just look at the law and say the way the law is written, it implies that, but it would be foolhardy for anyone to say let us pursue a criminal case in that matter. It is just too much of a stretch.
All right, we appreciate your perspective. Thank you very much indeed for coming through. That was Khaya Sithole, political commentator. Meanwhile, the Public Protector, Advocate Busisiwe